We are here on a couple of matters. Number one is a motion, an emergency motion that was filed regarding water service. And then as well, there is a motion that was filed by the plaintiffs seeking an amended rental amount. I'm also aware that there is, I think, a motion for attorney's fees under 91514 that was filed. And of course, all of this is complicated by the fact that the case has now been docketed in the Court of Appeals. Let me start by asking this question. One of the reasons that I understand that there was a conflict that Mr. Downs had regarding the defendant's motion regarding water service, but I also was advised through my staff attorney in two different emails that matter had been resolved. And so that's why I did not consider it to be an emergency, because by resolved, what I understood is while there might be some complaints back and forth, there was water at the property. And so that's why I was not concerned about canceling that hearing based on Mr. Downs's unavailability, and I believe properly filed conflict, if I'm not mistaken, or leave. And so I did want to mention that to make sure I understand that, in fact, the water is on. I'm not sure how it's being paid for or who's paying for it, but it is on and functional. And then I will start with, so I'll ask the defendants that question. I assume, Mr. Gunby or Ms. Gunby, that I'm going to hear from you, since I have seen that your attorney withdrew from the case.
Yes, that's correct, Your Honor.
Okay, and so you're going to be representing yourself at this point. I've seen some things that you filed that appear to be pro se. Is that right, sir?
That's correct, Your Honor.
Okay. So you did file a motion seeking an emergency motion regarding the water service at the property. And I don't know how long the water was turned off and what issues arose from that, but am I correct that I think I understood from your email traffic and Mr. Downs's response to my staff attorney that the water was off for some period of time but has been restored. Is that correct, sir?
That's correct, Your Honor. It was off for approximately 10 days, but it was eventually restored.
And are you paying for that water, or is Mr. Badam or Mr. and Mrs. Badam paying for that water?
No, that was the point, Your Honor, is that we were unable to transfer the account into our name. It was prohibited by the watershed management.
I'm familiar with their policies about leases and ownership deeds, et cetera. Yes, sir.
Ownership. So yes, yes, it is restored, and I think our only consideration at this point would be just to ensure that, you know, this sort of interruption doesn't happen again, and I'm sure we'll get on to discuss that as part of the other motion that we're hearing.
Okay, thank you, sir. I am glad that it has been restored, and we will move on from there in terms of going forward. Mr. Downs, the other matter that was to be heard today was related to the Badams request that the monthly amount, which, am I correct that is $2,850 currently? I know it was lower previously, or is that a multi-month payment that I keep seeing in the record?
It's 2580. Sorry.
I'm
Will.
sorry, Mr. Downs, what were you saying?
Oh yeah. Yeah. Am I on? I'm not unmuted. Okay, yes. It's 2580.
Okay, I had the numbers backwards, sorry. 2580 and 2850. Okay. And the purpose of this hearing today was to talk about what that looks like. Can you start for me, Mr. Downs, with whether or not you believe the court has jurisdiction to enter such an order now that the case not only is under appeal, but has actually been docketed in the Court of Appeals, I think about 8 days ago?
Yeah, it does, Your Honor. OCJ 44756 specifically contemplates on appeals to the Court of Appeals or Supreme Court, the tenant shall pay all sums found by the trial court to be due for rent or future rent into the registry. So, even though there's an appeal, the trial court retains jurisdiction over this type of motion, and also, as you know, the 91514 as well.
I was confident that I still had a jurisdiction over the 9/15/14 motion, but I was less, and I also this one, but wanted some reassurance regarding that matter, to make sure that the parties are on the same page.
Yeah,
Miss,
it's similar to like a supersedious, right? I mean, you would retain jurisdiction over that to fix that amount. This is essentially what that is.
okay,
May I?
Mr.
Oh, I'm
Yes,
sorry.
Mr.
Sorry, Your Honor.
Gunby, I was actually going to call on you and ask you what your thoughts are regarding that issue.
No, I mean, I think, Your Honor, I think we would argue that that the statute referred to by Mr. Downs and the plaintiffs. I think we believe the purpose and intent of the registry payment during appeal is to effectively maintain the status quo and protect, obviously, the landlord from loss. I don't believe it's intended to provide any profit or to function as a financial barrier to our rights or defendants' rights to appellate review. So our position is that increasing the rent from 2,580 to 5,500 is not maintaining the status quo, as referenced the statute, but it's a substantive modification of the case while it's under the jurisdiction of the Court of Appeals. So I think we would respectfully argue that a move to stay the motion on that basis.
Okay. Okay. Let me back up for a moment though. And I know you're not a lawyer, but I guess what I want to make sure of before we get into the substance of it is whether, Mr. Gunby, you are taking the position. It sounds to me as if you are taking the position that the court should not, for the reasons you just discussed, should not change the dollar amount because it is about maintaining the status quo. My question right now is really more basic than that, which is, are you going to make any argument that the court can't enter any such order because it's on appeal to the Court of Appeals?
Yes, I think that would be my primary argument, Your Honor. But I think I'd also say that if this court chooses to go to the merits, we would have some arguments to deny the increase, based on certain points that we would like to make.
Okay, thank you, Mr. Gunby. So I am satisfied that this is either specifically related to supersedious or that it is a collateral matter, et cetera, regarding that the court is able to address while the matter is pending on appeal substantively. And so I think it makes sense for me to actually hear from the parties regarding what adjustments should be made. And so, Mr. Downs, it's your motion. So what information, I did see some filings more recently. What information are you going to, what evidence are you going to present the court with regarding this issue?
Yeah, I just wanted to have Mr. Badam testify about his, research into the fair market rental value of the property and his ongoing expenses, for the property, just by way of comparison. At the time, just by way of a little bit of background, at the time when we did the initial rental motion, it was kind of early in the case, so we just kind of base it on what the current mortgage was at that time. Um, you know, and subsequently that during the case ended up increasing, so we were actually coming out, under what was owed. But based on the law, I kind of cite the court to there's a couple of cases about, like post foreclosure cases where there was no written lease in place between the parties. And in those cases, the Court of Appeal says that, the amount of rent that should be due is the reasonable rental value if no prior rent had been established. So that's what we would just argue at this point. Now this case is on appeal and potentially, pending for another 6, 9, maybe even 12 months. Is that it wouldn't be fair, to the property owners in this case for them just to have the mortgage paid. They should be entitled to the fair market rental value of the property.
Right. And I understand the argument. I guess I am curious about a couple of things in terms of establishing a reasonable rental rate. If no prior rent has been established. And of course, if there's a lease, then there's clearly some rent established. But if I recall correctly, there was some evidence in the trial of ongoing agreements to pay a certain amount. And I'm drawing very far back on this, considering how many things have intervened. But I want to say it was somewhere in the range of $1,100, and that those payments were very hit or miss and not consistently made. But one question the court would have is, even if that's true, would either that amount in the history of the parties' relationship or the amount that was established by the court during litigation, would either of those things be a prior rent having been established?
I don't think so, Judge. I mean, I think, there was no written lease. I mean, maybe there was an oral lease, right? But there's no written lease. So, you kind of then become into the tenant at will kind of situation where there is no lease. And the prior amount established by the court, I don't think it would preclude in any way, Your Honor, from reconsidering that. I mean, we didn't present at the time the fair market, rental value argument, in order really to kind of be more simplistic about it, because the case was already so complicated, with the fact pattern as it was. Initially, we just kind of like, our decision was like, let's just keep it simple. Let's just keep it to what the mortgage is. But that's not actually sufficient to make the Badams whole. I mean, they were paying more than just the mortgage, payment in regards to the house. So,
Understood.
yeah.
Okay. So I will hear from Mr. Badam now, if you want to call him as a witness.
Okay.
Mr. Badam, will you raise your right hand?
Yep.
Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you, sir. You may lower your hand. Go ahead, Mr. Downs.
All right, Mr. Badams, just, don't want to waste too much of the court's time, but you did undertake a review to determine the fair market rental value of Colwood Court, did you not?
Yes, did.
Okay. And you provided that, or we provided that to the court in the form of the spreadsheet, is that right?
Yeah. Yes, did.
Okay. Can you see the screen all right?
Yes, I can.
Okay. All right. So just kind of explain, what you did to the court to determine, what the fair market rental value of Colwood Court might be.
Well, I looked online for comparable properties. Some of them are here. I spoke with a realtor from Atlanta Fine Homes, and I spoke to friends of ours who are currently renting their properties to get a feel for what the market was like. The Colwood Court is in the Riverwood School District. It's a very sought after school district. There is very low inventory in that school district of a comparable nature. And so on the sheet that you can see, the first 1, 2, 3 comparables, and I did that on bedrooms, and sort of you can see the difference in square feet. They're not in the school district and they don't have a pool. The only property that is the size, around the size comparison for Colwood Court is very close. It's 2 streets down from Colwood Court on Riverside Parkway, and that has a pool. It's only a couple of 100 square feet different, and you can see that the rental that's been requested for that is, over $10,000 a month. So the school district and the pool it commands a very, very high premium, and the inventory is extremely low. So setting the rate at 5,500, I think, is reasonable and does not cover the financial cost, the total financial cost of what we're having to outlay while this process is happening and the Gumbys are living in our house.
And speaking of your financial outlay, you we also provided another, sheet to the court. Is that what this is?
That's right. Yeah.
Okay. And so this is your, well, just kind of explain to the court what this is.
Yeah. Okay. So the first sum is the current mortgage taxes insurance, the escrow. Excuse me. The water is an estimate because I haven't received a water bill yet. But that will be an estimate. That's in line with what it was previously. The HVAC is a lease payment that I have to make every month. And the pest control is as it is. Because we live in a much smaller house than Colwood Court, we need to pay for storage. And that's our current rental where we are. And we've just moved here to save some cost because previously we were having to pay $3,668 a month. And now we have moved to another property because of the appeal, which is now $2,750. So our total outlay, because we can't get into our house, is just over $6,000 right now.
All right. That's really it, Judge, unless you have further questions for Mr. Badam.
I do not.
Okay.
Are you done with your questions, Mr. Downs?
Yeah, I mean, that's it. Yeah.
Okay. Mr. Gunby, do you have questions for Mr. Badam on those issues?
Sorry, apologies, I was on mute. No, Your Honor, I do not.
Okay, thank you. Anything else you offer, Mr. Downs?
Yeah, just, I mean, by way of just explanation for how the process works, because Your Honor may not be familiar with how these registry payments work, is that it's often, just so the court knows, very difficult to get the payments. So from when, the Gumbys make the payments, I mean, it's often, we got to get an order, from Your Honor, and then deal with the clerk, and the clerk has rules on how long the money has to sit into the registry to be paid. So often by the time, the Badams even receive the check, it's, 2, 3, more months later. So, given that as well, I mean, I think that the fair market rental is, more than reasonable, to certainly compensate them for the time delay as well.
Understood. Anything else, Mr. Downs, before I hear from anything that Mr. Gunby wants to present?
No, Your Honor.
Okay, Mr. Gunby, your response, sir? Do you want to call a witness, or do you want to testify on your own behalf, or do you want to just make argument?
I think I'd just like to proceed with making argument, Your Honor. I don't intend to call a witness.
Okay.
So if I may go through a number of points.
Yes, sir.
So yes, a number of points I'd like to make. I think just going back to the statute, and again, as you rightly noted, Your Honor, I'm not a lawyer, so I apologize now if I'm off on certain points. But yes, I think the first point I'd make is that I believe the registry is a protective shield, and I think its purpose is to ensure the landlord doesn't lose money or be out of pocket during the appeal. We don't believe it's intended to grant the landlord any kind of market rate or profit, and so I would say under that prior lease, under the registry order. So I think that would be the first point I would make. I think if I may go on, the second point I would make is that and I think do you have visibility of the exhibits, Your Honor, or do I need to present those on the screen?
Both. You can present them on the screen if you want, but I do have access to the docket and to the materials that the parties have submitted if you want to reference them. Okay,
I would just make sure I've got the exhibits on screen just in case. So
sure.
So I think the first point I would like to just cover, following on from that last point. I mean, we would contend that the plaintiffs are already oversecured. and that the court should deny the motion based on the court's own finding of fact during the trial. On the record and actually with reference to Exhibit B, which I can put up on the screen. And that is a reference to the trial transcript. So looking at page 180, lines 12 to 16 of that page, the trial court stated, I don't think there's really any dispute that several $100,000 at least paid by the Gumbys to the Badams, and that amount exceeds what would have been a reasonable rental. And so I think we would say, because the court has already found that the plaintiffs are in possession of several $100,000 of our money, an amount the court explicitly stated exceeded reasonable rental, I think we would argue that the plaintiffs are already oversecured, if I can use that expression. So I think on that we believe any increase in the cash registry requirement would not be equitable, and in fact would constitute a double recovery for the plaintiffs. The hundreds of thousands of dollars already held by the plaintiffs should be credited, in our view, against the market rate difference. And I'll talk about that in just a moment, until the Court of Appeals determines the final merits of the counterclaims. So I think that's and I'm assuming you're looking at the Exhibit B there, Your Honour.
Yes, sir.
Okay, so if I then would like to, I think further we'd contend that the plaintiff's motion is actually not a good faith financial request. We feel it's a retaliatory tactic, and I reference now Exhibit A, which was a letter that plaintiff's counsel sent to our former counsel on the 27th of January, an email explicitly threatening further litigation and action if the defendant did not drop the pending appeal. When we refused to waive those constitutional rights to an appeal, the plaintiffs, in our opinion, knowingly caused the water supply to be cut off, despite the communications we made, and filed this motion to more than double the rent. So, I think we feel that is a form of self-help and retaliation. I would further go on to say that as we said, that the water was willfully suspended, and I think under Georgia law, a party seeking equitable relief must come to court with clean hands. So a landlord who engages in illegal self-help and sends written threats, in our view, should be barred from seeking the court's help to increase its the financial burden. I think the final, if I may, Your Honour, the final point I would make would just be to address the reasonableness of the current rent payments that, as you said, were $2,580. So I think with reference to the exhibits shared by the plaintiffs, we note that the current amount does cover the plaintiff's mortgage and utilities. So the plaintiffs are effectively being made whole every month. There is no irreparable harm justifying an increase of 113% to $5,500, and we feel that's punitive. But to address the point specifically, we object to the plaintiff's affidavit and the Zillow data. An affidavit from a party with a financial interest is not an independent appraisal. Furthermore, the Georgia courts have consistently held that Zillow's estimates are hearsay and do not meet the standard for expert testimony. Without a licensed appraisal of or a comparable analysis, there is zero admissible evidence here. So I think the last point I would make on the exhibits, Your Honour, is that we would argue that the plaintiffs are trying to have it both ways. They submitted a list of their personal expenses, rent, storage, HVAC, etc., to justify the 5,500, and then use a Zillow estimate to try and reach that number. So I think we would contend that the defendant is not responsible for the plaintiff's personal rent of $2,750 or storage of $450. That's not rent for the subject premises. The mortgage and utilities, mainly the water, are already covered. So their mortgage is $23.28, as I understand. The pest control is $100 and the water is $60. So the current registry payment of $2,580, they are already receiving more than their actual carrying costs. So I would just, if I can just make a conclusion, Your Honour, on the sort of final, I think we would argue, as I have already said, that this court is currently without jurisdiction, and I take on board Your Honour's previous comments on that. I think even if the court reaches, as we are now, to the merits, the plaintiff's request for 5,500 is based on inadmissible hearsay from Zillow, and a list of their own personal expenses, including their own rent and storage, which are legally irrelevant to the rent for this property. So I think because the plaintiff's already receiving the 2,580, which exceeds the mortgage and the utilities, and because they already hold, as I've said, and I referenced earlier from Exhibit B, they already hold hundreds of thousands of dollars of our money, and they are fully secured against any loss. So in conclusion, we respectfully ask this court to deny the motion for the rent adjustment in its entirety, or in the alternative, to offset any perceived market rate difference against the significant overpayment that the plaintiffs already possess. So I thank you for hearing me, Your Honour, and I hope I've captured our argument as concisely as I can for you.
Thank you, sir. Mr. Downs, it's your motion, so you get to respond.
Okay, sure. Well, I guess first off, Mr. Gunby, his calculations were, incorrect on what would even make the Gumbys whole. I mean, I think if I added up their actual expenses for the property, and it's $2,874. So that's actually more than they're actually receiving currently. Just based on their actual expenses. It includes the HVAC, the water, and water is an estimate, Judge. I mean, Mr. Badam put $60.
I have to say, based on my water bill,
yeah,
it's actually a low estimate, probably.
It's a low estimate, yeah.
City of Atlanta, so, and they have a bigger house and a pool, so
Yeah, I mean, a pool. I mean, summertime's coming up. I mean, so I mean, and just briefly, I mean, I know we're not here on the water issue, and that's been resolved, but look, it's incorrect that we just simply cut it off. I mean, we gave them notice that it's actually incorrect that they couldn't get the water service established in their name. They just didn't try. If they had gotten,
well, there was some evidence of it in the trial about the fact that the Badams were continuing to carry the utilities, partially because of the difficulties of having it changed over into a non-owner or non-lessee's name. If there is additional information in the since then I would hear that from you. But if we're just sort of calling back to efforts that were allegedly made or not made during what led up to this litigation.
No, it's Mr. Badam, after, once they refused to try to get the water in their name, had to go down to Watershed himself, and they explained to him it would be easy for the occupants to get water in their name. Mr. Badam would just have to be a guarantor, for the account. And instead of, not knowing what was going on in regards to the water, Mr. Badam just, put it back in his name, because he didn't trust that they would, do the right thing and pay the water, or, because anyway, whatever. It's really a non-issue, but it's incorrect that they couldn't get the water service. They just didn't try. The other thing, Your Honor, ChatGPT is great for a lot of things, but it doesn't really get the law right on a lot of stuff. We put in our motion that, Mr. Badam, as an owner, can testify as to market value. OCGA 24-7-701B, direct testimony as to market value is in the nature of opinion evidence. A witness need not be an expert in that subject matter to testify if he has reasonable basis or has opportunity to form a reasoned opinion. Mr. Badam testified about his efforts, to form an opinion. Mr. Gunby has not presented any evidence to counter that. He hasn't discussed his own Zillow research or anything to counter that. And in fact, he knows, presumably, based on his own efforts to potentially look for other locations, that 5,500 is a reasonable amount for property in this neighborhood. And it's not like, and I guess the last point I'll make is just the frustration about the procedural posture of this case and the frustration with this being a dispossessory, right? If this were a normal case, a normal civil case, we would be entitled to a supersedious, and supersedious contemplates damages, for the appeal and for the delay on having to wait, for the resolution, because there's virtually no chance this case gets reversed, by the Court of Appeals. It's only being appealed to delay or extract some sort of, concession from the Badams for not wanting to wait for another year. So, because we're not entitled to a supersedious in this case, we're left with, the statute, 44-7, was it 56 or 46, 56, and it contemplates fair market rental value. That doesn't mean the Badams are getting any sort of windfall from this. They would, believe me, they would much rather have the property than have any, monthly fair market rent, paid into court. They're not getting rich on, even if Your Honor were to, enter fair market value. That's why we showed their expenses. They're having to rent another property. I mean, this is just basically keeping them afloat while this, essentially frivolous appeal is pending.
May I finish, Mr. Downs? Your Honor, may I make some reversion on the comments made by Mr. Downs?
This is a little less formal, so I will let you, but understand that technically it is the plaintiff's motion, and so the plaintiff is always going to get the last word. So at some point, it's always going to be that Mr. Downs gets to respond and nobody else gets to talk. But I will let you respond briefly, sir.
Thank you, Your Honor. I just would like to make a couple of clarifications. I think, first of all, I would say that, as noted in the affidavit that was signed by my wife, it's absolutely untrue that we made no effort to restore the water, and I think the suggestion that we didn't is absurd. Secondly, I would say the calculations that Mr. Down was referring to that I'm apparently not very good at, I did not include the HVAC. That is a lease payment that is made by the property owner. So I think my last points would be, I think opposing counsel is putting words in my mouth or assuming that that I'm out looking for other properties. He has no basis for saying that whatsoever. He doesn't know whether I'm looking at other properties or not. And my final point is for him to say that an appeal is just an attempt to delay. I would say it's our constitutional right. So I leave it there, Your Honor.
Understood. Mr. Downs, anything to add?
No, Your Honor.
Okay. So here's what I am stuck with, right? So I previously ruled, and I understand Mr. Downs' argument that the 2580 number was a conciliatory type number, right? That was designed merely to get something in place and not really intended to be a reflection of fair market value, but more a reflection of the Badams' hard cost associated with that mortgage. I understand and have been provided with some evidence regarding fair market value, such as it is. I also have been provided with some evidence regarding the value or I'm sorry, not the value, the actual hard costs that the Badams are incurring. And I think where I end up coming down in terms of trying to look at whether, fair market value at 5,500 versus the actual expenses is that while it is unfortunate that the Badams are forced to pay for a different house, even though the court's ruling was that they were entitled to have their house, at the end of the day, that is not a new situation. That is a situation that the Badams sort of voluntarily allowed to occur for a decade or better. And so I don't know, even if your intention in showing me that, Mr. Downs, was not necessarily to say they're entitled to recover this as much as it was to show hard costs that would justify. I do struggle a bit with the Gunbys being called upon to pay for the rent for the Badams to reside somewhere else. Because as you correctly conceded, it's maybe unfortunate, but at the end of the day, this is not supersedious. This is fair market value. And so what that leaves me with is whether there is a justification to move from what is the mortgage payment, right? Or at least it was at the time, or to some higher amount that would be the mortgage payment plus the expenses associated with maintaining the house. Since the Badams are required to pay those things and the Gunbys are not paying for them, although they have indicated some willingness to do so. Or that all of that is really a non-starter because the statutory provision is for the payment of rent, not the covering of costs that are being associated. Because of course, in a traditional circumstance, right, this is about gaining access to the property. And oftentimes it is not in the context of the owner trying to get into that property. It's the owner trying to lease that property to another tenant, et cetera. And this is a weird situation anyway. Having said all of that, I think that while I appreciate and understand Mr. Gunby's expressed concerns about the quality or caliber of, any Zillow type evidence that the court might hear, what I have heard, whether it is it is a lay opinion, but what I have heard is that Mr. Badam has developed an opinion about what the fair market value of that property is at the 5,500 range. And he has not attempted to, although that opinion may be informed by his research using online databases, he has not attempted to present evidence of this property's fair market value based on Zillow, et cetera. He's given me his opinion. And I think that is something that the court can accept. I do not, full disclosure, I don't find it reasonable that even if Mr. Gunby doesn't plan to leave, I don't find it reasonable that Mr. Gunby, given the current legal situation, I find it unlikely that the Gunbys have not also looked to determine what type of property they might be able to secure, because as it stands right now, although they may be successful on their appeal, at the end of the day, there is currently a court judgment that says the Gunbys are not entitled to access or possession of that property. And so for that reason, I am going to grant the Badams motion, and I am going to enter an order requiring fair market value rent in the amount of $5,500 beginning April the 1st. Today, I think my review of the docket indicated that rent had been paid consistently for each of the months so far, including March. And that going forward, starting with whatever I think it's April 1st through the 5th is usually when the parties are given time to do that. And the court will grant the Badams motion and require that. Mr. Downs, can you please send me a proposed order that requires that? Now, the other thing to keep in mind, I know it is a pain to deal with the clerk of court, and it is unlikely that the parties could agree, but in cases where the parties agree, I've absolutely had circumstances where the parties agreed to make payments directly to one another rather than into the registry of the court. It seems like there is enough baggage and history that that might not work here, but that would certainly alleviate the delay associated with it being paid into the registry of the court and then the delay associated with getting it paid out. But I can try to speed that up in terms of sort of standing order, to the extent that once it's paid in, I can more routinely, rather than doing it, I mean, you could do it on a monthly basis where every time it's paid in, you can draw it back out. It just requires a little bit more administrative paperwork on your and my end, rather than doing it on a monthly basis. And there is still always going to be delay because the clerk has, of course, to make sure that those funds are good and that they're credited before they get paid out again.
Yeah, I think it's 21-day hold, they said.
Yep. It is to the extent that, as I said, the water has been restored. I am not making, that the motion that was filed is essentially denied as moot because the water has been restored. So there is not an emergency or a basis for the court to compel Mr. Badam to restore the water because it has been restored, and whether it was turned off on purpose or not is a different matter entirely. What I will say is that the status quo has been that the Badams were paying the utilities, and I think that is what needs to continue. And I'm sure that your attorney, Mr. Downs, can make sure that the Badams understand that it is not lawful to make a property uninhabitable by any self-help measure to get someone to vacate a property. Now, whether those general premises of the law that I am aware of actually apply in this particular and very unique context is an open question. But generally speaking, I would advise that the parties should not, the parties should continue in the status quo while this occurs and make sure that the utilities continue to be paid in the manner that they were previously paid, particularly given that the amount of rent that will be provided would provide a little extra cushion to enable the Badams to pay for those utilities. That's going to be the court's ruling. Mr. Downs, if you will send me a proposed order, I will get it on file, and then I will expect that new rental amount to take place take effect rather, starting April the 1st.
All right. Thank you, Your Honor. I'll send that over shortly.
Okay, that concludes this proceeding, and I will see the parties at some point later once I have time to process the 9/15/14 motion and response in terms of whether a hearing is necessary. Because my general understanding is that although this matter is on appeal, I do want to look and make sure as to whether the court was required to reserve it, et cetera. It does appear to me that that motion was filed on the 45th day after the judgment, which means it would be timely. And that generally speaking, assuming the court has the authority to rule on it, my understanding is that the Court of Appeals would prefer that the court rule on it so that it can be added into whatever appeal to the extent it gets appealed if the court enters any award or refuses to enter any award. And so I expect that I will be handling that motion at some point, but it will not be today. The parties will get notice of what we'll be doing that at that time. Anything else, Mr. Downs, for today?
No, Your Honor.
Anything else, Mr. Gunby, for today?
No, Your Honor.
Okay, thank you all. Have a